All right, hello everyone. Welcome to the webinar today. My name is Adam Carlson, and it's 2 p.m. Eastern Standard Time, and we're going to kick off the event as planned. This is our first event in Ontario, and we've had about 100 companies register for this event. It's very exciting to be talking to all of you today. Again, like I said, my name is Adam Carlson. I've been an account executive here at LawRoom and a training expert for about 8 years now. Helped thousands of U.S. and global businesses train their employees on compliance issues. Some of the organizations that we work with are Red Bull, BDO, some other companies such as Zoomies and Build-A-Bear that have employees in Canada also use our compliance training. Presenting on today's topic is Douglas Kelly. Douglas is our head of legal editorial here at LawRoom and a California attorney with experience in litigating employment labor law disputes, both before state and federal courts. He's an expert in North American compliance laws and regulations and spearheaded our compliance course for Ontario Bill 132. Since this new bill came into effect this past September, we decided to organize a webinar to discuss the implications for Ontario business following the new mandate. Throughout the presentation, feel free to ask questions throughout, and we'll respond in a timely manner. Douglas, thanks so much for presenting today, and let's dive into the topic.
Great. Thank you, Adam. I'm a lawyer and a writer. Hello, everybody. And what I love doing is breaking down new laws and policies to provide practical takeaways for you and your companies. With that said, we'll be going over some statutory language and some pretty heavy legal concepts. So I have to advise that I can't give legal advice in that regards to you. I think if you have any questions, I urge you to go to your compliance team or legal team in-house to address those. But I am super excited about this topic and to be talking to you all today. The agenda for this 30-minute webinar. We're going to go over Ontario Bill 132 a little bit, and then we're going to go over the new definitions it creates, and the new elements of your workplace harassment program, new duties, and how training fits into all of that. So let's kick it off by getting into Ontario Bill 132. And so this was a bill that received royal assent in March 2016, and then it's been effective since September 8th. Of this year. And to clarify, it amended quite a few laws in Canada, but what we're talking about is the amendments to the Occupational Health and Safety Act. So that's just to clarify, if you hear this around in the workplace or outside and you hear Bill 132, it could be a variety of laws, and we're talking about the Occupational Health and Safety Act in this presentation. A little background about California. So California passed a similar law, so it was AB 1825 back in 2004, and where employers of 50 or more employees had to train supervisors on sexual harassment. And throughout the years, we've kept up with the legal updates and made changes in our courses. What I find really interesting is recently, this past April, is California regulators required new content in employers' sexual harassment policies. They clarified definitions of who is protected and really made explicit the duties that employers had to resolve complaints. And the reason I bring that up is because a lot of the language that's in Bill 132 is found in the most recent California amendments. So I was really excited to jump into this content and really provide great takeaways I found in my practice and my research for you all. So we're going to first talk about new definitions. One is defining workplace harassment. Workplace harassment now includes workplace sexual harassment, right? And so as you will see on the slide, I indicated the new language in orange text. So the black text was there before, that was already your duty. Now, anytime somebody's protected characteristics such as their sex, their sexual orientation, their gender identity or gender expression, if that's being implicated in any sort of harassing conduct that constitutes workplace sexual harassment. And we'll get into those terms a little bit later. And then finally, they added about sexual solicitations by people in power that's unwanted. And what this is really talking about is, in often cases, there will be allegations of a subordinate that their supervisor, their direct supervisor, is engaging in harassing conduct. And so the Bill 132 amendments wanted to make sure that that was explicit, that this constituted sexual harassment. And it's really about power. And I'll talk about that later as well. And so what I wanted to do is provide the definitions of sex, sexual orientation, gender expression, and gender identity for you all. And I want to point out that throughout the presentation, I made citations to where this conduct is from. And these have been great websites that provide really full explanations of different terms and duties. I want to highlight gender expression and gender identity. So gender has been a huge issue in 2016. And after talking to employers and employees alike, while the social consciousness is changing about how we treat transgender people or the LGBT community, it may not always be reflected in the workplace. And so I wanted to explain gender expression. And so somebody publicly presents their gender, right? A person could dress in stereotypically female garb or manner of dress, and that's their gender expression. And gender identity is a personal experience of gender. That's what they consider themselves to be. So it's somebody who can look like a stereotypical female and then present and feel as if they were a man. And again, I recommend you go to these sources below in the links. And then so I found examples from the Ontario Human Rights Commission, and I selected a few that I really feel address the spirit of the Bill 132 amendments. And so anytime a supervisor is interrupting an employee during meetings, such as a female employee. Any comments on physical appearance? That separates them apart from male employees, right? And notice how I put these gender pronouns in brackets. And so this is really interchangeable. And I think what these examples are getting to is that anytime you separate or distance anybody based on their sexual orientation or gender expression, that's an issue. That's an issue that could possibly constitute workplace sexual harassment. Anything that makes them feel unequal in the workplace. So for an example of gender identity, if an employee addresses and makes clear that they want to be called Mr. or Sir, as opposed to Mrs. or Miss, that should be respected in the workplace. And then anytime somebody doesn't address them as that, that's one further piece of evidence of sexual harassment. And to be clear, that should be prevented in the workplace. So that's what these amendments are getting to, thinking carefully about how we address people in the workplace and treat each other. They carved out an exception, really more of a clarification that, this shouldn't prevent anybody from being able to discipline or direct subordinates if they're violating policy or code or workplace conduct policies. So you're still allowed to do that and not be afraid of implicating any sort of laws. The difference is really that targeting, that somebody feeling separated from everybody else based on protected characteristics. And then so that takes us to the first takeaway, is this concept of monitoring language, attitude, and power. Language, we're not just talking about pronouns, we're also talking about how people are addressed in the workplace. If a female is referred to as sweetie, or actions are adorable, or her work product is cute, right? These are like language concepts that are separating people based on their gender. Attitude is another concept. Anybody rolling their eyes, any sort of detraction from appropriate code or conduct, is an attitude that could be reflected in separating people based on their gender or sex. And then finally, this concept of power. Look carefully at any type of relationship between a supervisor and an employee. And if it seems exceptional, I mean, it should be really further scrutinized because supervisors are in a position of power, and the new law amendments really reflect that, and we want to make sure employers are keeping tabs on that. So that is the first takeaway I would get from these new definitions that were created on workplace harassment. Next, we're going to talk about the new elements that must be part of your workplace harassment program. So I addressed, what already existed before Bill 132. And so your harassment program, you needed to make available your policies on workplace violence and workplace harassment. And you also needed to incorporate those policies into a larger program. And so the difference between a policy and a program is that when we're talking about programs, we're talking about action. Policy is what you have down on paper, and your program is how those are actually implemented. And so what Bill 132 did is it actually provided very explicit action plans that must be part of your policy now. And so these 4 are below. And so you need to physically write down how you will handle a complaint of workplace harassment. You need to be very specific and thorough in addressing that. You need to provide somebody the contact information other than a subordinate supervisor of who they can contact. Oftentimes this is human resources. And be very specific about the contact information, the phone number, the office location about this person. And this is to address the fact that, again, that power dynamic is many times a subordinate will allege their supervisor is harassing them. And so this is to make sure that the employer knows about these allegations and complaints. Third, you must make confidentiality how it'll be maintained in your workplace. And then so you must physically write down into your policies that you will keep confidentiality unless you have to disclose their personal facts for the investigation or for any sort of corrective action, or if it's required by law. And then finally, it's how, if you receive a complaint of harassment, you need to inform both the alleged harasser and the complainant of the results of that investigation and how you plan to resolve it. And so, to be clear, these are all concepts that must be written out in your policy, and you must be explicit about these in your program. And I provide the citations below. I think this is my favorite slide of the entire presentation. So what often happens is all employers have policies, and they put a lot of time to create them, and then bills like Bill 132 will come in and add even further ones. But as we all know, you can have policies, and there's a difference between having policies and employees who follow them. And so I am fascinated by that dynamic, and how do we make sure employees are going to follow these policies that you are tasked of enforcing? So that comes down to culture, and decalogues have been written about culture. But what I've done a lot of research on this, and I provided 3 really simple takeaways you can take away right now in ensuring that you're building this culture of compliance. And by building this culture of compliance, you can bridge the gap between employee conduct and the workplace policies that you implement. And so one is this concept of tone at the top. Does senior management and the executive board, do they care about compliance and employees' complaints and their well-being? If they do, it's going to make your job easier. If they don't, that message is sort of lacking throughout the entire organization, and you might have trouble sort of making sure these policies are being implemented. Another concept is legitimacy. Do employees believe in your code? Do they believe in your policies? This is at first a personnel issue, particularly in hiring. Are you hiring people that are going to fit in with your core values? But it's also about sort of conduct on the grounds. You have these policies, are they being enforced? Or are employees violating policies but not being disciplined or punished in any way? Are punishments being doled out in a fair manner? And the reason I bring this up is employees really notice these little nuances. They notice when a coworker is not following an expense policy, let's say, and there's no recourse. That sends a message to the employee that maybe the codes and policies of the employer aren't that important, or they don't need to follow them. And so maybe the argument goes, if they don't respect an expense policy, they're not going to believe in your sexual harassment policies and how you show that their complaints will be taken seriously. And that's related to management. The third topic is, are supervisors setting a good example? Just like employees notice the little things that happen around the workplace, they really look to their supervisors to provide guidance and example. And so if your supervisors appear to take policies seriously and follow them, that's going to be great. However, I will warn you, if supervisors roll their eyes or don't take compliance seriously, the law, or are personally not following policies themselves, that sends an extremely bad message to employees, again. And so these are things you can look for in building a culture and helping your employees meet these new policy and program requirements. Second takeaway, you want employees to complain. For some people, this might seem counterintuitive, but the Bill 132, what they're really trying to do is make sure that complaints and allegations and concerns are addressed early, so you can take it before it's a firestorm, and really before harassment can take place, because if that takes place, people can get hurt, and we all want to avoid that. And so you want employees to trust in your system and complain. New duties. So these are duties you have already had before. You've had to have taken steps to prevent and respond to sexual harassment complaints, whether they're informal or formal. You need to have the ability to identify those. What Bill 132 does is being really just more explicit about your duties as an employer. And I want to clarify that, before we talked about what must be in your program, what must be action-oriented, and these are different. These are similar, but you are now expected to comply with this within your full ability and practice. So one of those is conducting an appropriate investigation, considering the circumstances. This is pretty wide, despite being so explicit. And so what does this really mean? And so what this really means is proving you really tried to resolve the program. That's an appropriate response, that you took a complaint seriously. Second, just like we covered in policies, you need to inform both the worker and alleged harasser in writing. So not only is that something that must be physically written into your program, it's also your duty. You need to make sure it happens. And then finally, reviewing your workplace harassment program every year to make sure it's being implemented effectively. That is now your duty. You must do that every year. And so I'm not going to go through this guidance, but I found examples of what shows an employer is meeting their duty to prevent harassment and how that's considered. So again, I urge you to go down to the links below, and especially the Ontario Ministry of Labor updated their website to provide real examples of what they're expecting you to do in regards to conducting an appropriate investigation and resolving complaints of sexual harassment. And so this concludes with the third takeaway in regards to your employer duties. And so you need to prove that you really tried to solve the problem. And what I like about this word prove is it's always important to document the actions you take in the workplace. It's good to show regulators or people who ask. But really, what I like about it is by proving, that means you will take actual steps and tangible steps in addressing a complaint of sexual harassment. And that builds an accountability to your system, that you're doing everything you possibly can to address concerns that come up. So that's what I mean by proof. And then finally, this is the last leg of our presentation, and it's about training. So what does the Occupational Health and Safety Act say about training? So it has training requirements. There's a training requirement that the basic rights of workers under the Act and the duties of employer are communicated. And then there's record-keeping requirements. And I provided the regulation down there to provide you reference to specifically look at the language of what exactly is required. But beyond that, and this has always been my approach to training, is let's say there was no requirement at all and you didn't need to train on it. It's really an opportunity, because these concepts like workplace violence and workplace harassment, they can really damage employees and workplace morale. It causes great, emotional pain, almost to the effect of or equal to occupational hazards, like physical things in the workplace. And then so I think all employers really should look to finding ways to reduce the risk of harm to all employees, supervisors, and subordinates alike through prevention, how we can all prevent workplace violence and workplace sexual harassment. And training is absolutely one way to get there, if done effectively. And then the sales organization wanted me to put this in the slide. So these are the courses that LawRoom offers. I wanted to point you to what the Ontario Ministry of Labour said about workplace violence in particular. And I wanted to make clear, because this program was really about workplace sexual harassment. And what they said is training could be used as a tool. Now I want to be clear that it's not a requirement, but training could be used as a tool. But it's particularly effective if it provides prevention strategies, how to prevent workplace violence in the first place before it escalates. And I know the workplace violence training does that in that regard. It provides red flags and prevention solutions for employees and supervisors. And with that, I'm really done. I just wanted to make a quick plug for the blog we have at LawRoom. We post a lot about sexual harassment, discrimination, ethics programs, compliance programs, and it's very well researched. And so I urge you to log in and join and look at our content in that regard. And so I think my time is up, so I'm going to kick it back to Adam to provide more details. And it was my sincere pleasure in speaking to you all today. These are important topics, and thank you for having me.
All right, well, thank you, Douglas, for that. That was great. And for everyone listening today, we'll send you over a recording of this presentation and also the slides as well, so you can see the links that Douglas provided. And so we'll send those to you shortly after this. And feel free to share those with any colleagues you have in Ontario. And those who have requested a demo before, I'm going to have Jalen reach out to you in a little bit. But before we go into that, I just wanted to quick background on who LawRoom is. LawRoom's been around for about 20 years, been providing online compliance training since 2004, when AB 1825 in California came out, like Douglas mentioned. We have 10 attorneys on staff, to help ensure that all of our courses are up to date and compliant with all the new laws that come out. This year alone, we're about to train 6 million employees and students, anywhere from, we work with Harvard University, Stanford, and many companies, like I mentioned before, like Red Bull, Zoomies, and many others. And I think we train a little over 3,300 corporations and universities rely on us for compliance training with Douglas and his team. So that's a little bit about LawRoom. I just wanted to share that with everyone. And like I mentioned before, those of you that requested a demo before the webinar, I'll have Jalen reach out to you so we can schedule some time, over the next week or so to kind of walk you through and show you our training platform. Anybody that would like a demo that's on the phone that didn't request one before, feel free to write in the question box demo, and either myself or Jalen will reach out to you to set up a call and go through our full platform. All right. Well, again, I want to thank everyone. I want to thank Douglas again for presenting on that. And I'll keep this open for a little bit longer if anybody wants to request a demo, and we'll reach out to you. And if you have any questions, feel free to reach out to myself or Jalen. And again, thank you very much.
Thank you, everybody.